Thank you, Acting President. I rise to speak on the Justice Legislation Amendment Vicarious Liability of Child Abuse Bill 2025 on behalf of Legalise Cannabis Victoria. I rise to speak on this issue for a range of reasons. It is personal to me. Like a lot of us, I have many people near and dear to me who are survivors. I know the pain and deep suffering that abuse by trusted adults causes victim survivors. It should not solely be on them to fight the battle for both recognition and compensation. They deserve nothing less than for those of us in positions of power to stand with them and shoulder some of that burden. I think it's quite comforting that every member of Parliament who has made a contribution today has reassured survivors that they are standing with them and that this legislation will pass because it is the right thing to do. And I want to acknowledge everyone's contribution today because some things are just above politics, and I appreciate everyone's commitment to seeing the passage of this bill. Now, I say to survivors that I see you and I stand with you, and I am sorry that this fight has often been so lonely and so hard. I also have a number of constituents in the South East who are victim survivors of institutional abuse. As your local member, I will always be a voice for you in Parliament. Legalise Cannabis Victoria is a party of law reform, but underneath that is a bedrock of social justice. We are a party of compassion, and we believe in doing what's right. To this end, early last year I stood in this place and I second-read a private member's bill, the Wrongs Amendment Vicarious Liability Bill 2025, to make certain organisations vicariously liable for the abuse of children by persons akin to employees of these organisations, to effectively close that absurd loophole. Now, this was in response to the 2024 decision in the case of Bird and DP, where the High Court held that the Roman Catholic Diocese of Ballarat could not be held vicariously liable for known historical child sexual abuse because the perpetrator, Father Coffey, was not an employee. Because of the High Court's reluctance to establish vicarious liability outside of the strict employee-employer relationship, this created a second class of victim survivors who will struggle to access justice, including those abused by non-employees like volunteers. The common sense and just approach is as follows. Where there is comparable authority, control and power given to a perpetrator because of their position in an organisation, and that perpetrator takes advantage of that position to perpetrate abuse of a child, it should not matter if they have the title of employee. It is arbitrary and unjust that existing laws allow some, but not other victim survivors, the opportunity to pursue relief through vicarious liability. The High Court itself said law reform in this area was the responsibility of the government and of us as a parliament. With the bill before us today, I'm glad to see that the government has accepted the High Court's invitation to reformulate the laws of vicarious liability and address the harsh outcomes from the Bird and DP case. Victoria has never been afraid to lead the way when it comes to responding to institutional child abuse. Now, proudly, Victoria was the first jurisdiction in Australia to remove civil limitations and create a fault-based legal duty to prevent child abuse. While it took some time from when I introduced essentially the same bill last year, the government has thankfully now introduced legislation to right this wrong. This brings me to the Justice Legislation Amendment Vicarious Liability for Child Abuse Bill 2025. This bill specifies the circumstances in which an organisation will be considered vicariously liable for abuse of a child by an employee of the organisation, and provided when an individual will be akin to an employee of a relevant organisation. I'm glad to see that the government's bill will also give courts the flexibility to respond to the circumstances of each case and apply to all organisations that exercise care, supervision or authority over children, drawing no distinction between the kinds of organisations in which abuse may occur. While we are so pleased with this bill before us today, this is spiffing legislation. There are, however, opportunities for minor improvements and clarifications to improve its operation for victim survivors. On that note, we will be moving an amendment to this bill, and I ask that the amendment now be circulated. Thanks, Michael.
If we could get them circulated, please. Ms. Payne, to continue.
Thank you, Acting President. Section 93C of this bill provides that in determining whether an individual is akin to an employee, a court may consider whether the individual carries out activities as an integral part of the activities carried on by the institutions. We heard from a range of stakeholders with concerns on the use of the word integral in this bill. In fact, when drafting the private members bill last year, I received similar feedback and chose to adjust the language accordingly. That's why we're moving this amendment today, to change the language from integral to ordinary activities in order to close any further loopholes. This change brings us in line with the laws passed in the ACT and ensures we do not create an unnecessary high burden of proof. It should be enough that someone is part of the ordinary activities of an organisation. They do not need to be integral. We've also heard from stakeholders with a range of queries about how certain parts of the legislation are intended to operate, and we'll be canvassing these in the Committee of the Whole stage. I would like to take a moment now to thank the many stakeholders whose tireless advocacy helped secure the bill before us today. Now, I won't have time to name everyone, but I especially want to thank Dr. Judy Corton from Corton Legal, Susan Ackery from the Victorian branch of the Australian Lawyers Alliance, National Survivors Foundation and Sexual Assault Services Victoria. Thank you for all the support you've provided and information to me. While it is disappointing that the government did not support our bill last year, to change these laws is in essentially the same way. We are pleased to see that they have accounted for this delay and it will be retrospective. This bill will enable a person to apply to the court to set aside a settlement or judgment that occurred between the 13th of November 2024, which is the date of the Bird and DP decision, and the commencement of this bill before us today. This ensures that no victim survivor with a claim impacted by Bird and DP is left materially worse off because of any delay. That is not to say that all is well. While we waited on the government to make these changes, victim survivors have been left in limbo. Cases were adjourned and settlements delayed in the hope that changes to the law would occur on time. A schoolboy at a religious boarding school, a youth volunteer at a railway organisation, an attendee at a church Sunday school and a youth member of the Guides Association. All young people who were victims of child abuse at these organisations and were denied access to justice simply because their perpetrator was not technically an employee and impacted by Bird and DP. This delay had both practical impact and a huge mental health impact on the community. Now, on that note, in supporting this bill, I want to acknowledge the many thousands of victim survivors across Victoria and Australia. I particularly want to thank every single survivor who has reached out to me, who has engaged with me, who has at times encouraged me as well, because your engagement and encouragement have got us to where we are today, and I thank you for your commitment to the outcome we are seeing today. We hope this bill makes the all too difficult fight to access justice that little bit easier. And today and every day we stand with you on that road to justice. I also want to thank the Attorney-General for her commitment and engagement. And I particularly want to thank the Attorney's team, who have been an amazing group to deal with. And I think that there is so much work that has happened behind the scenes here. It's important to acknowledge that everyone has been committed and provided a lot of clarity along the way so that we do come to this positive outcome. On that note, though, we do hope that the following passage of this bill means that the Attorney-General will continue their work at the Standing Council of Attorneys General to encourage other jurisdictions to make similar changes. So on behalf of Legalise Cannabis Victoria, I commend this bill to the House. Thank you.